Thanks to a middleman, I was able to get in touch with Jan Marsalek on July 25, 2022. In this way, however, I only had the opportunity to send a letter to him without any certainty of an answer. In this letter, I report on my background and my previous findings as part of my investigative work. In the letter, I list the overwhelming amount of evidence that leads me to believe that the German judiciary has its protection money laundered through Wirecard. Since I am addressing him with my letter and requesting him to get Wirecard's business data in order to search for the money launderers, I must first explain to him what leads me to believe that he has this data. To do this, you must first focus your attention on his escape. Jan Marsalek was able to escape right in front of the prosecutor's face, obviously at the last minute. I ask whether the public prosecutor's office can really have been that stupid. If a public prosecutor's office has someone like Jan Marsalek on their radar, a high profiler, then he won't run away from you. When I met lawyer Liebscher at Berlin Central Station in June 2020, I was able to explain the structures at Wirecard Bank to Mr. Liebscher in a personal conversation. We had the conversation on an empty platform, but we were surrounded by prospects. Only secret services have the audacity to eavesdrop on lawyers' conversations. They must have been even more after Jan Marsalek than me. It's hard to imagine that it was so easy for him to flee from the public prosecutor's office. Besides, there must be more behind it. In my letter to him, I come to the following conclusion. I'm looking for you because I assume that you caught large parts of the German judiciary laundering money in the business data of Wirecard AG. How do I come to this assumption? First of all, the German judiciary is stupid. But on the other hand, it's not stupid enough to let you escape. So it's obvious that you used your knowledge to blackmail your escape from the Munich public prosecutor's office. On December 21, 2020, Attorney Tilp also received my dossier on the failure of the BaFin to supervise Wirecard. After I had filled out Mr. Tilp's questionnaire and returned it, we had a detailed telephone call with his team on January 6, 2021. Earlier, on September 14, 2020, I had a similar phone call with the attorney Mr. Mattil. During the phone call, I asked Mr. Mattil why he was not suing BaFin for official liability like Mr. Till. Mr. Mattil drew my attention to a case in which a lawyer had already sued a large German authority for public official liability and was subsequently sentenced to imprisonment. I couldn't verify the case, but it seems plausible. If a precedent sentence were to be set, as Mr. Tilp was aiming for, by which German authorities could be held liable for damages in the event of misconduct, that would create a huge problem for German authorities. Such a gateway would render authorities almost incapable of acting if they were regularly held accountable for their mistakes. In my telephone conversation with Mr. Tilp, I did not have the impression that he was aware of the fact that a red line was about to be crossed, despite his great successes to date. Mr. Tilp apparently believed in the rule of law to the end. Due to his mysterious death, I filed a criminal complaint for murder under file number 11, UJ's 2394/21 against unknown persons on June 14, 2021. However, the Tübingen Public Prosecutor's Office dropped the case after me describing the circumstances. My complaint to the General Public Prosecutor's Office in Stuttgart was also rejected. If you use the bankruptcy of Greensill Bank as a comparison, which was of a much smaller scale, you can see many parallels in the misconduct of the management with Wirecard. One thing between the two scandals, however, is particularly striking. The secret services weren't the least bit interested in Greensill. So Wirecard must have been something special if everyone wanted to get involved somehow. I provided Jan Marsalek with the answer to this question in my letter of July 25, 2022. The next clear indication of money laundering by the German judiciary at Wirecard is that the German judiciary cannot launder their bribes at banks abroad. This would make the German federal government vulnerable to be blackmailed by foreign state governments. At banks in Germany, on the other hand, laundering money is not so easy due to the strict supervision, even if the anti-money laundering offices in Germany are chronically understaffed and mainly concerned with questions of responsibility. Unlike Greensill, Wirecard was not an accounting scandal, but a money laundering scandal. In my letter dated February 26, 2023, I am informing the insolvency administrator of Wirecard AG of the following. Dear Mr. Jaff, after you received the order to resolve the Wirecard Group, you probably couldn't have believed your eyes. At the time of the insolvency, Wirecard Bank held well over 200 million euros in central bank deposits. This means that a large part of the proceeds from the sale of Wirecard Bank to the Santander Group consisted of liquid funds. The remainder of the proceeds comes primarily from the valuation of the bank's customer portfolio. At the Wirecard Bank, a problem in the calculation of the liquidity coverage ratio, LCR, meant that the bank had to hold an exceptionally high amount of liquid funds in its Bundesbank account. The LCR considers all transactions with a remaining term of less than 30 days and calculates a ratio from the balance sheet assets and liabilities. This must always be above 100%. However, the bank's system landscape had the problem that only the assets on an individual transaction basis, and thus maturities, were available. The liabilities were not delivered. In a time of need, the entire balance sheet liabilities were used to calculate the ratio. However, balance sheet accounts do not have maturities. As a result, the outflows considered were very large. The ratio was catastrophically bad. In order to solve the problem, the entire balance sheet was also used for the already correctly calculated inflows. Nevertheless, liquid funds of more than 200 million euros had to be held in reserve in order to reach the ratio. In order to solve the problem and get an indication of how high the actual LCR ratio is, I built a complete semi-automatic calculation core. Using a correct calculation, the Wirecard Bank would have had a ratio of well over 400% and thus had the opportunity to dispose most of the funds tied up in the Bundesbank account. At the time, one would probably have bought other high-risk startups, and these funds would not have been available to the insolvency administrator. On the one hand, I was able to dissuade the bank from using my calculation because no one but me could use it. On the other hand, as part of the planned core bank migration, it was foreseeable that the ratio would soon be calculated correctly. At that time, I could not foresee that the company would go bankrupt, nor that the migration would fail 3 times by then. However, this circumstance meant that Mr. Jaffe was able to repay an additional 200 million euros to the creditors. I continue to write to Mr. Jaffe. The reason why I am presenting you with this detailed report is that, in the course of the sale of parts of the company, you surely did not just try to sell the bank's customer portfolio. In this way, you were finally able to redeem several hundred million euros. You will also have tried to sell the rest of the group's customer portfolio. The moment you realized that didn't work, you should have asked yourself why there is non-alienability in this case. If you have not already found the answer to this question, allow me to explain the background to you. A banking license is required to engage in lending business. In order to keep the scope of the supervised business small, the company only transferred those customers to the bank with whom lending business had been agreed. As a result, the rest of the customer business was not subject to the supervision of the authorities. BaFin, Bundesbank, EBA, ECB, etc. As a result, these transactions were not subject to any review of the application of proper KYC, Know Your Customer, measures by the supervisory authorities. Likewise, unlike the lending business in the bank, there was no requirement to have this business monitored by AML, anti-money laundering systems. Industry insiders who took a look at the publicly known customer portfolio and the corresponding creditworthiness could easily anticipate what the rest of the business outside the bank must look like. Even without knowing that Wirecard's business structure was an open invitation to money laundering, no board member of any bank would have touched this portfolio with a 10-foot pole. Since Jan Marsalek did not get back to me, and there was no answer to the help I offered to the Munich public prosecutor on January 16, 2021 to search for the money launderers in Wirecard's business data, I was still looking for this data. I also write to Mr. Jaffe. As an insolvency administrator, It is your job to liquidate the assets of an insolvent company in the best interests of the creditors in order to service their registered claims. This means that you not only make an inventory of the company's assets, but also for the creditors and create a ranking for servicing their claims. This gives you a total number of creditors. Of course, only the creditors who have registered their claims with you will be compensated. As a money launderer, you try to remain as unnoticed and unknown as possible. Consequently, money launderers will not have any claims lodged with you. In order for me not to wait any longer for an answer from Jan Marsalek, I urge you to compare the total number of creditors against the number of creditors who have registered claims with you. The unregistered claims identified in this way are either immaterial or they are money launderers who, in order to protect their anonymity, have not registered any claims with you. On March 21, 2021, Mr. Jaff refuses to release the money launderer's data. On July 13, 2023, I filed a criminal complaint against Mr. Jaffe for aiding and abetting money laundering. The Munich public prosecutor is conducting the proceedings under file number 400 and 2Gs 164,959/23. On July 19, 2023, Focus wrote about the court hearing against the board members of Wirecard AG. According to various reports, Marsalek is said to have fled to Russia in order to be safe from the German judiciary. This description hits the nail on the head. I am writing to Jan Marsalek. Your situation explains to me as follows. Please correct me if I'm wrong. You've caught politicians, prosecutors, judges, and policemen laundering money, probably by name search. Then you looked at the opponents and found even more money launderers. It should have quickly become clear to you that the scandal is so big that too many people involved have too much interest in the scandal not being uncovered. Under no circumstances, exposing the scandal would have put your life in danger. So you were forced to continue this scheme. But it was also clear to you that things couldn't go on like this forever, especially since the money launderers intended to milk the golden calf until it would drop dead one day. Since the exodus was inevitable, you took precautions not to walk away with empty pockets. I would have done the same. Of course, you won't like to hear that. I have filed criminal charges against you and the rest of the board for aiding and abetting money laundering. That's probably the only thing you can seriously blamed for. Everything else that you are accused of is due to the fact that you were indirectly forced to do it. From the people who want to put you on trial. What irony. Jan Marsalek could not have filed criminal charges against the people, who would then have had to investigate on themselves. Jan Marsalek, therefore, did not flee from criminal prosecution, but, as reported by Focus, from the judiciary instead. In my telephone conversation with Mr. Q, Mr. Tilt's colleague, who is continuing the Wirecard proceedings at the Tilt law firm, I had not received an answer on the state of affairs of the lawsuit for official liability against the BaFin, which led me to believe that the proceedings are operated seriously. Mr. Q gave the impression that he did not want to make the same mistake as Mr. Tilp. Mr. Tilp believed in the rule of law. Mr. Braun believes in the rule of law. Jan Marsalek did not believe in the rule of law. I don't believe in the rule of law either. In Season 4, Episode 3, I will explain why.